This video is the Informed Consent training session for the United Way Integration Project. In this video, I'll outline some of the principles and guidelines of informed consent. My name is Kelly Davila. I'm the Senior Research Analyst at the Polis Center. At the end of the presentation, I'll provide my contact information for myself as well as the Institutional Review Board for Indiana University if you have any further questions. Some of the major objectives of this presentation are to describe the project itself, what we aim to do, what the goals are, and define some key terms as are put forward by the federal government for human subjects research. I'll outline a couple of historical precedents for informed consent regulation, why it is that these are federal laws, and I'll review some tenets and principles of informed consent, generally how the process would go. You'll learn how to have a conversation with a client about informed consent, and we'll review the consent form. We can also discuss many different types of clients who may be consenting to participate, as well as some special cases where clients need some different treatment than others. We'll also identify some barriers to properly collecting informed consent and ways to overcome them. So the purpose of the project generally is to better understand the scale, scope, and impact of nonprofit services on families and individuals in Central Indiana. We know that many organizations help improve the lives of people in our communities, and we also know that many of the organizations serve the same families across the city or across the region, but we don't know which families and we don't know how many. We don't know exactly how many people are serviced by United Way agencies as a whole. We also don't know which factors contribute to the best outcomes for families. So because the data is not centralized, we can't analyze it across multiple agencies. So this project is intended to develop a centralized data set so we can collect information from multiple agencies and better leverage that data to improve client outcomes. Since some families are receiving services at multiple agencies, which we know, we want to make sure that that combination of services yields the best outcome for the family. For example, this could benefit the agencies by distributing funding to better leverage those combinations of services. Some key terms, these are all from the United States Code. The references at the end of this presentation for your information. The federal government defines research as a systematic investigation, which includes research development, testing, and evaluation, which is designed to develop or to contribute to generalizable knowledge. Human subjects are defined as living individuals about whom investigators conduct research and about whom they obtain data through intervention or interaction with that individual or identifiable private information. This project actually does both. Private information, according to the government, includes individually identifiable information. So that is the identity of the person, the subject, is readily ascertained by the investigator or associated with the information about that person. So for example, the person's name, that's private information, that's identifiable information. And throughout this project, we will be collecting that sort of information about clients. So why do we do research on human subjects? The short answer is that people are complicated. It's difficult to simulate their thoughts and behaviors, and it's certainly difficult to simulate how they utilize and how they leverage different kinds of services and the outcomes that they may experience as a result of those services. So doing research with living people in the field allows us to better observe that complexity and can help us, understand new information about, for example, service provisions or learn more about medicines and technologies that can have an impact on society. So is this human subjects research? Short answer, yes. So we want to study client data to provide information that can improve client outcomes, so that is research. We're collecting that information about living people, that's human subjects. The data that we will be collecting is through interactions. They will provide us that data. The interaction, or otherwise termed intervention in this project, is sharing their data, and that the data is personally identifiable. We can use it to identify them. Therefore, we have to conduct this research under an ethical framework, and there are several historic precedents for that as well as modern precedents. I'll start with historic precedents. One of the earliest examples of using ethics in human subjects research is the development of the Nuremberg Code in 1946. It was a response to the Nuremberg trials of Nazi war crimes. During that trial, German scientists and doctors wanted to use the defense that no document existed that outlined legal versus illegal experimentation on human beings. So 2 American doctors who were working with the prosecution on that case started considering what that kind of document would look like. And their ideas about what such a document would look like was submitted as a section of the verdict. The document included lots of major points on human subject research that are still being used today. One of the main outcomes of that was that voluntary consent for experimentation was absolutely essential and that benefits must always outweigh the risks. The code is comprised itself of 10 principles of legitimate research, which have themselves formed the foundation for most countries' laws on human subjects research. For example, in the United States, the National Research Act was put forward in 1974 as a response to the Tuskegee syphilis experiment. During that experiment, Black men, mostly from Alabama, mostly poor sharecroppers, were recruited. Some had syphilis and some did not. And as a compensation for their participation, they were receiving medical treatment and burial insurance during the time they were enrolled in the subject. This experiment went on for decades, for more than 40 years. And at some point very early on in the project, money ran out to provide them with those services that they were told they would receive. So the doctors there kept recruiting men and never told them they had syphilis and also didn't treat them for it. Even after penicillin was proven to cure syphilis, they weren't treated with penicillin. And after about 40 years, somebody associated with the project leaked the information, and that's what paved the way for the National Research Act to become law in the United States. Finally, the Belmont Report was drafted in 1979, and this lays the kind of current moral and ethical framework for understanding research in the United States. It establishes 3 principal tenets, which are collectively known as the common rule. The first is respect for persons, which means that the autonomy of all people should be protected. Informed consent should always be sought, and researchers should always be truthful with people about what will happen to them or their information as a result of participation in a project. The principle here is to never deceive your research participant. Beneficence just means do no harm. The goal here is to maximize the benefits and minimize the risks for anybody who's participating in a project and for the benefit of society. Finally, justice. Research design should be reasonable, they should be non-exploitative, the procedures should be well considered, the costs and benefits to society and participants should be distributed as equitably as possible. So the Belmont Report also guides researchers through several different processes, including informed consent, which I'll talk about at length in this presentation, as well as a risk-benefits assessment and the selection of study participants. So informed consent itself is the process of discussing the risks and benefits and options and obtaining permission to conduct an intervention on an individual. Again, in our case, an intervention is the sharing of that person's data. It can be as simple as asking a question, which is what we're doing. Can you share your data with us? Or as complex as a risky surgery. The guidelines cover everything along those spectrum. So anybody who obtains written or verbal consent must be properly trained to conduct that process, which is why you're watching this video. An informed consent is only given when an individual has a clear understanding of the facts regarding their involvement in the research and knows the expected outcomes of that study. So the 3 main components of informed consent include the conversation, having a dialogue with the client or the individual about what it is you're asking them to do and why, and what the risks and benefits of that are, which also includes listing out some facts about the project. I'll cover those in some detail too. At the end of that conversation, the client will sign a form. I'll cover the form verbatim in this presentation. It's important to note also that the forms themselves need to be maintained by the organization at the time. Forms need to be kept on file at the organization. Copies need to be sent to me. So it's important to understand that talking to clients about informed consent itself is a process. It's not just obtaining the signature. It ends with obtaining a signature, but the informed consent process itself is not just to get that signature. So to properly ensure that the client is giving their informed consent, your staff is going to be responsible for assessing the individual's capacity to give that consent, providing information about their involvement and what the study intends to do, answering any questions the client might have there in real time to improve their comprehension of the study and what they would be asked to do if they chose to participate, and obtaining their voluntary consent to participate in the study. Even if the client is capable of providing their informed consent, they don't have to. Nobody has to participate in the study. It's 100% voluntary. The client has the ultimate decision as to whether or not they participate in the study. And it should have no effect on the services they receive. If a client does not sign the consent form, they should still receive services as they normally would, as anybody normally would at your organization. So assessing an individual's capacity to consent may help to define what capacity is. In adults, that's the ability to understand the nature of the research and their participation, as well as to appreciate the consequences of their participation. You'll be asking people to share their data, so they need to understand what data about them would you be sharing, and what does it mean if their data is, for example, breached in a database. They need to show the ability to consider alternatives, including not participating at all, and then also demonstrate the ability to make a reasoned choice. If they choose to participate, that needs to be done in a reasonable context where you don't think that they are, for example, under some duress or feel like they need to in order to receive services. It's important to always bear in mind that the individual may have the capacity to consent and still choose not to, and that is their choice. Some people temporarily lack the capacity to consent. For example, those under the influence of alcohol. Anybody who is under the influence of alcohol should not be consented. That consent is not valid because they're not capable of making that reasoned choice. And some subjects otherwise lack the capacity to consent. For example, if the subject has a medical power of attorney, the state of Indiana says that medical power of attorney needs to sign this form. So when talking to clients about informed consent, in the process of framing this project, we've realized that most agencies have said that they anticipate most of their clientele will be able to consent themselves or their children. So for children, you need to have a legal parent or guardian. Most people or most agencies have indicated that this is going to be the case 90% of the time for them. So in this situation, we're asking that you introduce the research project itself and your agency's participation. Provide the consent form or an assent form if the child is between ages of 7 and 12, and any other supplemental forms which vary agency by agency. You'll ask the client to read the form and let them take their time reading that form, and also remind them that they can ask you any questions that they might have on the spot. They can keep that form, they can keep a copy if they would like to, and if they have any questions later, there's contact information for myself and for the IRB. They also don't have to make their choice to participate at that time. They can take the form with them and talk it over with anybody that they want to, and come back later and say that they either choose to participate or choose not to. It's important that you emphasize that it's their choice to participate and that their choice will have no effect on the services they receive. Making it very clear that the research project is entirely separate from the services that are provided is very important. So there's no single best way or regular process for initiating or conducting this informed consent conversation. So in my experience, I've found that it's best to just start with facts. I've laid a few of those out for you here. Your agency and others are participating in this study as a group, and you want to know if the client is interested to be a participant in this study. The purpose of the study is to create a data set to use in research, and that the research could help improve services and outcomes for clients at your agency or other agencies. And the study involves sharing personal information. That's information that can identify that person that will be shared external to your agency. You will provide the POLA Center with information about that client. It's important, again, to underscore that the client has the right to choose to participate. If they choose to, then your agency will share their data with the POLA Center. If they don't choose to participate, their data will not be shared. That choice is 100% theirs and does not affect the way that they would provide or receive any services from your agency. If they do choose to participate, your staff will send that data to the Polis Center, and once at the Polis Center, will be stored in a database and analyzed by staff at the Polis Center, and combined with data from other participants at your agency and at other agencies. This is an example of a way to start the informed consent conversation. You don't need to follow this. It's just a guideline that I came up with that may be helpful to some of you. Our agency is a part of a group of agencies who are asking clients with help for a research study. The study will produce information that can help us improve our services for you and for other clients. It involves sharing information about clients and their outcomes after receiving services. And I want to know if you'd like to participate. You don't have to participate. If you don't want to, nothing bad will happen. You'll still receive services from us no matter what. If you choose to participate, we'll give the research team data about you that we normally collect about clients and their outcomes. And data from all clients who agree to participate will be compiled by the research team and stored in a database. Researchers will use that data to figure out how many people are served by all the agencies and what all their outcomes are. They'll provide the agencies with information that can help us improve our services. So it's important to note that's just the beginning of the conversation. That's just what gets the ball rolling. And it's a lot of information for clients to take in at one time, especially during an enrollment process where they may already be looking at lots and lots of other forms that your agency has for them to sign. So it's important to make sure that they understand what it is you're asking and why, what their rights are and what their options are and what happens next. It's very important to note that the topic should be discussed in the client's preferred conversational language. We have forms in English, Spanish, Burmese, and Russian. We ask that if a client has a preference in the language that's not English or is not a conversational language that a staff person has, that you don't attempt to obtain informed consent from that person. And under no circumstances should you have a child translate for a parent or for any other adult. They should also receive the form that's in their preferred language. Again, those will be provided. And as the client goes through the information, or as you go through it with them, pause very often, read their body language, and remind them that they can answer, or that you can answer any questions that they might have. And again, it's very important to remind them continuously that their choice to participate or not will not affect the services that they receive from your agency. Legally appropriate consent form documents have to include certain sections. Our consent form has these in order and in headlines with each of these subjects enumerated. The first is that there needs to be a statement saying that the study itself involves research, and an explanation of what that research is, how long it's going to last, what are the procedures, what are any experimental procedures. We have no experimental procedures in this subject, so we're just laying out what exactly it is we intend to accomplish with their data. There should also be a section on risks. Any foreseeable risks or discomfort to the subject. In our case, the principal risk is that of a data breach. There should also be a description of the benefits to the subject or other people as a result of the research. We also need to disclose alternatives to participation that could be advantageous to the subject, including non-participation. The primary alternative to this research is non-participation. They can also choose to withdraw from the research at any time. We also need to include a statement describing the extent to which their confidential records will be maintained. And then the United States, the federal government, has the right to inspect those records. We have applied for and obtained a certificate of confidentiality that actually protects us from having to distribute those documents to any agency. The form should also include information about compensation if available. This project does not include compensation. We also need to state that there is no more than minimal risk. Minimal risk is just the probability that harm or discomfort are not greater in and of themselves than would otherwise occur in daily life. We don't believe that this project has any more than minimal risk, as they would normally share that information with your agency. And we've got lots of systems in place to protect data once it's in our custody. The form should also include contact information for the researchers and the institutional review board. In our case, it's going to be the IRB at Indiana University in Bloomington, that they can contact at any time in the event of any questions, concerns, particularly regarding their rights and the more information about the research itself. And finally, the form needs to include a statement that research itself is, the participation in the research is voluntary, and that their refusal or discontinued willingness to participate in the research will have no penalty to them. So I will go through the individual sections of the form and discuss how all of these 8 bullets are being met in our forms. First is the research statement. The red text that you see here is the description of how we meet the definition in the previous slides. The black text describes more detail about our project in particular. So this research project hopes to better understand the people who use services from some nonprofit agencies, what their outcomes are, and whether or not they use services from several agencies. The subject is invited to take place in the study because you're seeking services from the agency. We're asking you to participate because we're trying to learn more about the combination of services from many agencies that lead to improved outcomes for people and families. The project will last for at least 2 years, starting in June of 2017, but may continue beyond that time. Your forms may say April of 2017. This is the date that we received approval. I apologize, this is an old slide. If you choose to participate, you agree to share data this agency collects about you with the center. The center in this case is the Polis Center. You'll receive another document listing the types of data that your agency might share about you. Your data will only be shared if you choose to participate. And here, this mention of another document, some agencies have suggested that they want to provide the clients with a listing of all the data that they might be sharing. That's what this language is in here for. If you choose to participate in the study, you'll need to sign this form and give it to a staff member at this agency. If you do not wish to participate, you will not sign this form and your data will not be shared. Your decision to participate will not affect the services you receive. If you choose to participate, this agency will transfer your data to the center. Your data will be stored in a database and may be combined with records about you from other nonprofit agencies where you have given your consent. The center's goal is to create a list of people served and the services they received. It's important to note here that we aren't collecting any information about the client that your agency doesn't already collect. We're just collecting a subset of the data that is already collected by your agency. Your data may also be combined with your records from state agencies, such as the Indiana Department of Education. For example, we'll try to link records about student education outcomes like school performance, attendance, assessments, and disciplinary measures. The center will use this information to create summary reports about the programs and services by this agency and other nonprofit agencies. Summary reports will not contain any information that could identify you or anyone else participating in the study. The study will continue for 2 years. After 2 years, the study may be extended. While taking part in the study, there could be a risk of your private data being released. However, a very high level of security is in place to lower the chances of this happening. In case private data is released, the center will work with agencies involved to find out how the data was released and will act quickly to prevent the problem from happening again. The center or the agency involved in the release of data will supply relevant records, logs, files, and security reports to the correct parties. This is to follow the appropriate laws regarding data security, including laws related to any investigation as a result of a data release. It will not cost you anything to participate in the study, and you will not be paid to participate. You will not benefit directly from the study. No one will benefit financially from the study. The study will help United Way, this agency, and other agencies improve the services provided to all of their clients. The study will also help agencies make choices that improve the outcomes of their clients after receiving services. Efforts will be made to keep your personal information confidential, but we cannot guarantee absolute confidentiality. Your identity will not be disclosed in any reports that may be published as a result of the study, but your records may be shared if required by law. Organizations that may inspect and/or copy all or part of your research records for quality assurance and data analysis include groups such as the study investigator and his or her research associates, the Indiana University Institutional Review Board or its designees, and, as allowed by law, state or federal agencies, specifically the Office for Human Subjects Research Protections, who may need to access your medical and/or research records. You may choose to participate in the study or not. You will receive the same services no matter what you choose. There will be no penalties to you if you choose not to participate. You have the right to withdraw your consent to participate at any time. Nothing bad will happen if you do. To withdraw your consent, contact the agency's staff or the study team directly. If you withdraw your consent, the center will remove your personal information from its database to the extent possible. You are not waiving any legal rights by participating in the study. If you have any questions about your rights as a participant in the study, please contact the study team using the information below. So here I want to talk about the client's right to withdraw their consent to participate. It's possible that a client could say that they want to participate and then some weeks, months later decide that they don't want to anymore. We ask that you let the client know that in order to withdraw, all they need to do is tell somebody at your agency, but somebody at your agency needs to communicate that to the POLA Center. Agencies by this point should also have the ability to track that change in their database, to edit a field saying that the person has chosen not to participate anymore. If we've already received the client's data and we've already linked it to other data sets, any information that they've shared with us prior to their decision to remove themselves from the study will have to stay in the database because it will be linked to other records at that point. When they choose to not participate anymore, what happens then is the agency just ceases to share that client's information with us. So we won't have their information going forward, but we may retain that information going back. Finally, a section on contact information. If they have any questions about the study, my information is given, my phone number and my email address. For any questions specifically about their rights as a participant, they have the right to contact the Human Subjects Office at IU Bloomington. The phone number and email address is given. A situation where they might be interested in contacting the IRB would be if they had questions about their particular rights as a participant, any ethical questions about the research itself. If they have more technical questions about what kind of data are we collecting and what kind of research questions is the study team asking, those kinds of questions would go to me. Finally, on the form are lines for signatures. If the client is age 12 to 17, they have to provide either written or verbal assent. The parent or guardian of the client would then provide the consent for that child. We only need the signature of one parent or guardian, not necessarily both. We are not requiring assent for children younger than 12. This is because the IRB has determined that children younger than 12 probably don't fully understand the concept of sharing private information or data breaches. But between the ages of 12 and 17, we anticipate that they do. If the child has expressed interest in not wanting to participate in the study, their wish has to be honored. So if the child says, I don't want to participate, but the parent tries to sign them up, that can't happen. The parent has to go by the wishes of the child. However, if the child wants to participate and the parent does not want them to, the parent's choice triumphs over the child's in that case. If the client is an adult they just provide their written consent on the form. So in all cases, the subject's printed name must be provided. Knowing that the subject may be a child, we would print the child's name. The parent or guardian must write the date on which they signed the form, or the adult subject themselves. And the printed name and the signature of the person obtaining consent, that is a staff person at your agency, must also be provided. And it's important here to understand that the reason why this training is being provided and why an assessment test is being used at the end is because only the people who have passed this training can collect those signatures from those consenting clients. And because those forms will be scanned and delivered back to me, I have a mechanism for checking whether or not agencies are complying with that. That's an IRB rule. That's not a rule that I've come up with. So if the IRB chooses to audit the project, we just need to make sure that we're all in compliance. It's also important to note here that for electronic consent forms, which some agencies are using, you should know by watching this video, by the time you watch this video, if your agency is using those or not, that there is no assent for children under 18, mostly because if somebody is enrolling online, there may not be a staff person there to witness the child giving their verbal consent, so that assent is waived. But the parent or guardian must still provide the name of the child as well as their name when they sign that consent electronically. So one method that is commonly taught for delivering informed consent and for having the informed consent conversation is called the teach-back approach. This is routinely employed, for example, in the medical field, where doctors and nurses need to make sure that the client understands particularities of a procedure or a surgery. So in the social sciences, we also use this method. It's pretty effective. Using the teach-back approach, it's helpful to ask the client if they'd be interested in participating. And if they are, this approach can kind of help them come to a decision if they are on the fence. If they're not interested and they express the fact that they're not interested, don't attempt to persuade them into participation using this method or any other method. The teach-back approach has you ask the client to tell you in their own words what they believe to be true about the information they've just received. So it encourages the client to think about the information and also provides you with an opportunity to make sure that the client is making an informed and voluntary choice. To assess the client's understanding of the form and their involvement, their risks and benefits, and to ensure that they are making rational and voluntary choices, you can ask the client, what do you think the risks are to participating? What about benefits? I want to make sure that your choice to participate is clearly explained. Can you tell me in your own words what would happen if you chose not to participate? Or how might you explain the purpose of this research to a friend? These are 3 examples of questions that you can ask a client to get them to kind of repeat back to you the information that you may have just delivered. Only some agencies are covered entities, and these next 2 slides apply particularly to them. If your agency is not a covered entity, that is if you're not providing medical services to clients, then this is not relevant to you necessarily. But for those agencies, I'll go ahead and give that information. This research is also HIPAA compliant. So HIPAA is the Health Insurance Portability and Accountability Act of '96. And this law refers to covered entities, which are the agencies providing medical care and their relationship to the client as well as to this research. So HIPAA as an act is designed to promote the use of electronic health records by also ensuring that there are adequate security regulations in place to protect confidentiality of medical records and other protected health information. And this act emphasizes the secure handling of protected health information, which is PHI, that comes from a covered entity like a healthcare provider or a healthcare organization. Again, if you're unsure whether or not your agency is HIPAA compliant, it may not be. Please do ask somebody if you are unsure. So for the purposes of HIPAA, PHI, protected health information, includes any of these. For the purposes of this project, we are asking for things like name, address, telephone, email address. We are not asking for things like social security numbers, medical records, bank or credit information. So not all of this applies to this research, but if your agency is a covered entity and you even share something like a name, that's PHI, and then HIPAA applies. So we have to have a separate document. That's a HIPAA authorization form. Again, if your agency is a HIPAA covered entity, you've probably used these forms for other purposes to get medical records from previous healthcare providers. We do have a form specific to this project that emphasizes, again, what the project is about, what kinds of information about the client that may be shared with us, and allows the client to sign off on any or all of their health information. So again, this slide just covers the fact that if you are a covered entity, by virtue of what we're asking for, PHI is included in this research. So an additional form must be used for that. Only the client capable of consenting themselves or an appropriate legal representative can sign that authorization form. So again, in Indiana, power of attorney is the first person other than the client themselves or the client's parent or guardian. I can also go over a listing of other people who are capable of consenting those clients. I will go over that in an upcoming slide because it relates to something that might apply to more agencies. Again, if you're a HIPAA covered entity, you may already know what those groups of people are. And finally, the form does contain information about the project. Again, it specifies that PHI that the agency will share with POLIS and allows the client to restrict access to certain types of health data about them. So to recap, the full process of having an informed consent conversation includes introducing the research. And again, in my personal experience, I find it best to start with facts, provide the client the form, allow them to read the form and let them know that they can ask you any questions, and make sure that you give them sufficient time to read through the form. Once they've had that amount of time, ask them if they're participated in or interested in participating. If they are, you can use the teach back method to make sure that they understand the research and their involvement and any consequences. Make sure that they understand that their participation is voluntary, and make sure to remind them that even if they choose not to participate, the services that they receive at your agency won't be affected. They do not have to sign the form to receive services at your agency. If they're not at all interested in participating, don't attempt to obtain their consent. So only after they have expressed their understanding of the above, using the teach back method especially, you can obtain their written consent. And if applicable, depending on the client, have their parent, guardian, or legally authorized representative sign a HIPAA authorization form. So to quickly recap what we've just covered, we discussed the nature of the research itself, of this project in particular. We've also covered the purpose and the importance of informed consent. We've covered the standard consent form that we use for most clients, as well as the standard consent process for most clients. We've also briefly covered HIPAA and HIPAA authorization, which pertains only to agencies who are covered entities. So in the next slides, we'll talk about scenarios where a client may have limited capacity to consent, or have a representative who would need to provide consent for them. This is covering mostly what's in Indiana state law, which is subject to change. I can provide additional modules as that information changes in the coming years. We'll also review some vulnerable populations of people that you may be consenting. Vulnerable populations is a term used by IRBs to identify people who may have specific provisions in other acts or in other federal codes where additional care needs to be taken when discussing research with those clients. And finally, we'll talk about some common barriers to informed consent and ways to overcome those barriers. So So one of the more common groups of individuals that agencies may be consenting are wards of the state. There is significant procedural difficulty in obtaining this consent. And in many cases, especially given some of the limited capacity that nonprofit organizations have, consenting these clients just may not be possible because of the administrative barriers. I still need to go over the process of doing that. But we as a research team in United Way understand that it can feel impossible to consent wards of the state. So the process of consenting a ward includes contacting the child's caseworker or social worker, usually that person's at the state, and let them know that you want to discuss consent for the child's participation in the research project, and that you need to know who the legal representative for the child is. That you may already know who the legal representative for the child is, and you can talk to that person, but in the event that you don't, contacting the social worker is usually the first step for that process. So if the social worker or the caseworker provides you the contact information for that person, you need to attempt to obtain that consent from that person, as well as the assent of the child itself. In some situations, you may need to obtain consent from multiple parties or a judge. Obviously, this is procedurally difficult. You also must appoint an advocate for the child who's not related to the project, and who is not acting as the role of a parent to the child to give an alternative opinion to the child's ability to participate in the project. So once the child turns 18, wards and all children in general, they need to be reconsented as adults. Again, this process can take considerable time. It can be bureaucratically impossible to do. We understand that that's difficult. We understand that not all agencies have the ability to undertake this process. But again, I just have to provide the information to you. Again, it's very important to note that this should not at all interfere with the services that the client will receive. So if you choose to go down this road and it takes a year to get consent for the child should have received a year of services from your agency if they've been there the entire time. Assessing the capacity to consent for some individuals. There are some situations where the adult client's capacity to consent might be in question. And to consent those clients, you must first identify if the client is able to provide their own consent. If they're not, then identifying the appropriate representative needs to happen. In some cases, the client's legal representative will already be with them when they arrive at your agency. In my conversations with different agency executives, many have said this is the case. But in other cases, you might need to investigate to identify the representative. And much like with wards of the state, this can be administratively prohibiting. We understand that. Again, I just need to provide the information to you. If you are able to track down this person, then this is the way to do it. So there are several procedures for determining consent capacity and identifying the correct person to consent that client. And again, it can take considerable time and should not interfere with the services the client receives. So I've tried to break down the best kind of process for assessing the individual's capacity to consent. The first step, does the client have legal standing to make decisions to participate in research? Again, from my conversations with agencies, 99% of the time this is the case. So if yes, move on to the next step. If no, then ask the client if they have a court-appointed guardian or representative who can make that choice for them. In some cases, that appointed guardian or representative is with the client, and then you can proceed with the standard consent procedure. If that person is not with the client, then you might need to identify them and try to get in contact with them. So if the person does have legal standing to make decisions to participate in research, if you have any reason to believe that that individual is not capable of making a rational decision on their own half, you can go 2-3, and if you think that the person is totally capable of making that choice on their own, you just proceed with the standard consent. So if you are unsure that the individual has the ability to make a rational decision, try to determine these 4 things. Can they communicate a yes or no decision? Can they demonstrate an ability to understand relevant information? Can they demonstrate an ability to appreciate the situation and its consequences? And can they demonstrate an ability to manipulate information rationally? If you think that the person can demonstrate all of these things, you can just proceed with standard consent. If you have any doubt that they can demonstrate any of these, you'll go to number 4. It's important to note here that there's not really a test to figure out what these 4 answers are. You may have already gathered enough observational information in just your time with the client to figure out whether or not any of these are questionable. So if you've determined that the person cannot demonstrate all of those things, the first step is determining the appropriate legally authorized representative for that person. In the state of Indiana, that person primarily is the healthcare power of attorney. Alternatives to the power of attorney, which not everyone has, is the client's spouse, their parent, an adult child, an adult sibling, and then recently, as of August 2017, the state of Indiana has also included the grandparent to this list. So although the representative may choose to provide consent, you should still honor the client's wish to participate or not, meaning if you've got the ability, the capacity, the time to track down this person, and the client still does not want to participate, then you should not obtain the consent to participate that client. Other signs of limited consent capacity may include temporary limited capacity to consent, which would be influence of drugs or alcohol. Some common ways to identify whether or not the person is under the influence of drugs or alcohol include a smell of alcohol, poor coordination, reduced judgment, reduced inhibition, squinting or closing one eye, a delayed or an absent reflex, or a disheveled appearance. If you attempt to obtain consent from an intoxicated client, that consent is not valid. You can pursue consent at a later date for that client if you choose to. Also, if a person is undergoing physiological effects of drug or alcohol withdrawal, they should not be consented. You can also choose to pursue that consent at a later date. Another thing to look out for is whether or not a person has had a traumatic brain injury. It's possible that your agency may have programs for individuals with traumatic brain injuries. In some cases, you may not know. If you're concerned that the client may have recently had a traumatic brain injury or psychotic episode, you can ask the client to tell you what time it is, where they are, point to an object and ask them to describe it. Ask them to repeat a phrase back to you. But if you find yourself needing to ask clients these questions, you probably would need an alternative person to provide that consent. If you believe that the person may have just experienced a traumatic brain injury, obviously seek medical attention for that person immediately. Don't attempt to consent them. Similarly, if somebody has just experienced a traumatic experience, that can put them in a state of extreme emotional or psychological stress. Some signs to look out for include being tearful, sighing, appearing vague or confused, being very anxious, having a panic attack. These, again, your agency may specialize in providing services to individuals who've just undergone traumatic experiences, but if somebody comes in displaying these signs, you may not want to consent that person. You can choose to pursue consent at a later date. If you think that a client's in an emergency situation, obviously you should contact the appropriate authorities. Vulnerable subjects. These are groups of people who may be more prone to coercion than others. It's important to understand their vulnerabilities when discussing consent. And in some cases, administrative steps are needed to obtain that consent. These are three kind of large groups of those individuals. I'll go through each in some more detail. For children, because they're children, they are legally not able to provide consent for themselves. They can assent to participate, but they cannot provide consent. Their parents or guardians must do that. And in our case, one parent or guardian is sufficient. Children ages 12 to 17 can provide assent to participate. That is, they can just verbally agree to participate. The absence of dissent should not be considered assent. That is to say, if they don't say they don't want to participate, that shouldn't be construed as that they do. As with all clients, you want to make sure that the child understands and is willing to make that rational and voluntary choice to participate. And if they do not wish to participate, their choice should be honored. The parent should not be able to consent for a child that does not want to be a part of this research. Parents and guardians may and should discuss assent with their children, but the consent form should always be used in any case for the child. There's also an additional assent sheet. It's an informational sheet that does not include signatures that can be provided to children, which describes the research in a way that they may better understand. The assent form is written at a 4th grade level. The consent form is written at an 8th grade level. You can obviously use your discretion when using one form or the other, but it's important to note that the consent form is the only valid one. Signatures should go on the consent form. The assent form is really to just facilitate understanding of the research. Another vulnerable group of people that are very common to participate in research are pregnant women. Pregnant women are protected with special provisions that are designed to avoid harm to a developing fetus, but to ensure that they still are able to enjoy the same benefits of research as other people in society. They're allowed to participate in research with some limitations. So it's important to underscore to women that their participation involves no more than minimal risk and involves no risk at all and no harm to a developing fetus. And that's because this research pertains to the mother. We're collecting information about the mother, not the fetus. So with groups of pregnant women, it's just important to let them know that information collected about them is information that relates to themselves, to the mother themselves, not to the fetus. Finally, other groups. Among others, other groups of vulnerable subjects include undocumented immigrants, formerly incarcerated persons, and individuals with decisional impairment or developmental disabilities. And in these cases, it's really important to be sensitive to the position of vulnerability that these subjects are in. They may be more prone to thinking that they have to agree to participate in the research or that they should agree because you want them to. So it's really important to make sure that they understand that the research and the service provided by your agency are totally separate. Under no situation ever should you attempt to persuade a client to participate, especially with these groups. Using the teach-back method is a really effective way to gauge their understanding of especially whether or not they think that this is signing up for the research is necessary for receiving the services. So again, just remind them early and very often that their participation is totally voluntary and it will not affect any of the services they receive. In other situations, some groups may be fearful of sharing data, especially since the intent here is to link data with other data sets, including state government data sets. If they are not interested at all in participation for that reason, don't attempt to persuade them. That's totally fine. It is their choice to participate or not. But again, here, I think it's important to mention that we have obtained a certificate of confidentiality, which protects us from having to disclose any data about our research participants in any case of a subpoena or for any purpose outside of absolutely necessary legal purposes. This information is included on the consent form, but again, we understand that not all people will want to share their data, especially when it's going to be linked with state data sets. So to quickly recap this kind of second part of the presentation, wards of the state must have both a representative who may consent the child. This could be their whoever is in the place of a legal guardian for the child, as well as an advocate. The advocate can't be in the role of a parent and cannot be involved with the research. If you choose to consent a ward, that's the process to go through. If you believe that the client may not be able to legally provide consent for themselves, you should determine their ability to provide that consent and contact the appropriate representatives if needed. If you believe the client is under the influence of drugs or alcohol or in a state of extreme emotional distress, do not consent the client. If the client is a victim of traumatic brain injury or is cognitively impaired, you might need to identify a representative who could consent that client. Some clients are otherwise able to consent themselves, but may be a part of a vulnerable population. And with these groups, it's important to be sensitive to their position and concerns. Again, it goes without saying that under no circumstances should you attempt to persuade a client to participate. Their choice is 100% voluntary. So finally, we'll talk about some barriers to the informed consent process. In my experience doing this type of research, the #1 barrier to obtaining informed consent is not having enough time to spend with each client. We're not asking that agencies completely rearrange their administrative schedules to spend infinite time with clients, but giving the client enough time to really understand what it is they're being asked is very important to obtaining informed consent. Some people who are obtaining consent, so staff members, sometimes are very cautious about giving too much or too little information about the project. It's important to just be as truthful and as transparent as possible when describing these outcomes to clients, because this is something that's happening. It will happen to them, right? So if they're sharing data, that's an effect on them, right? Not on you. So there's no such thing as giving them too much information about this project. You should give them just as much information as they need to understand. In some cases, staff may not know enough about the project to discuss it clearly. I've also provided agencies with forms that describe the research project. I'm happy to share those again, but somebody on your staff should have that form available for staff purposes. Another barrier is that the clients sometimes perceive that this is just another form to sign to get services. This is kind of linked to not having enough time to spend with each client. If you're kind of flying through, 50 separate forms that they need to sign in order to receive a service. We just want to make sure that they don't think that this is a necessary form that they have to sign in order to get services from your agency. And that kind of goes with this next one, that the clients may be unaware that the research and the services are two separate things. Sometimes there are cultural, demographic, or language barriers. Again, we've tried to address that by providing the consent forms in 4 different languages and asking that agencies only use the forms in the conversational language of the client, and that they also have a staff person who can conversationally speak that client's language when discussing consent. But in this case too, it's also important to know that there are some populations of clients who may think that you want them to participate or that they have to participate. And these may be cultural, language, or cultural or demographic barriers. So it's just important to keep in mind that they're not required to participate, that it's totally their choice. Sometimes the language about the research itself can be overly complicated, or the client may be unable to comprehend the materials. To counter this, we've again provided the consent forms at an 8th grade reading level, as well as an assent form in a 4th grade reading level. This is why it's really important to have a conversation with the client face-to-face to make sure that they understand, and use the teach-back method to make sure that they really do comprehend the information that they've been presented. And finally, again, back to lack of time spent with each client. Sometimes there's just an inability to detect the client's lack of understanding, not really looking at their body language, or they're asking enough questions to really assess whether or not they understand. So these are generally some barriers to informed consent. Ways to improve that, so basically ways to address those barriers, are to ensure that there's sufficient time to discuss consent materials. Also make sure that they understand that they don't have to make that choice on the spot. We've tried to ensure that the consent materials themselves are easy to understand, and that we've provided the materials in many languages, and agencies offer interpreters to discuss materials. Using the teach-back method, you can assess what the client knows and maybe listen for things that they don't know or that they don't understand fully. Make sure that you empathize with the client's concerns and honor their choice. Ultimately, if they choose not to participate, that's totally fine. That is their choice. It's important to always tell the truth about the research, your agency's role in the research, the client's role in the research, to the best of your ability. And if you have any questions about anything like that, please refer them to me or to the IU-IRB. Generally speaking, always just kind of watch out for the client's body language and their reaction to your introducing the research and what they would be required to do, share their data with us, and be prepared for their reaction. Finally, just slowing down is a big part of giving them enough time and space to understand what it is that they're being asked to do. Here, it's important to avoid a bunch of technical language and jargon. Make sure that you're talking to the client at their level. Also make sure to pause and give them the floor to voice any concerns or problems that they might have, things that they may not understand, or just issues that they might have with the research in general. You can verify that the client has understood the materials by asking if there's anything confusing about the form or anything that you can help them better understand. The teach-back approach is effective for doing this. You can ask them, what do you think the risks are to participate? What are the benefits? Can you tell me in your own words what would happen if you chose not to participate? Or could you tell me how you would explain the purpose of this research to a friend? Those are all ways that you can gauge the client's understanding of the research itself. This slide just has my contact information, my desk phone and my email address, as well as the website for the Polis Center. I've also provided the IRB's contact information. Questions relating to technical issues or to the consent process itself can go to me. Questions about research ethics or kind of the mechanics of research oversight at IU can go to the IRB. If you have a question that doesn't fall neatly into either of those two categories, reach out to me and I will try to either find the answer or get you in touch with somebody who has that answer. And finally, here's some references and more information. I can circulate the PowerPoint so you actually have those links to click. You will get a link shortly for an assessment on what you've learned during this presentation. I will collect those scores and report back to the informed consent liaison at your agency with whether or not you can go ahead and start consenting clients. Thanks, and hope you guys enjoyed it.